Members, may you please report. I am Alan John Gregorio, and I will be discussing the second and third submissions of our weekend. But before doing this, I would like to ask the permission of the court to discuss first the third submission before going to the second submission. Thank you, Your Excellencies. We submit the third submission that Captain Joy is not liable for the crime of lethal killing under command and responsibility. We submit to Your Excellencies that Captain Joy is not responsible for the crime of lethal killing under command responsibility for the death of Alpha civilians and military personnel in Camp Z. The crime or the killing committed without him knowing or owing to the circumstances at the time that the forces were committing or about to commit such crimes. Particularly, we submit that the prosecution has failed to establish the second and third element of severe command responsibility. Specifically, under Article 78 of the Rome Statute thereof, provides that the superior must have either known or consciously disregarded information which clearly indicated the time that his subordinates were committing or about to commit such crimes. And the French version of this is that is equally authoritative in stating that the superior must have deliberately neglected to take into account the information that was available to him. However, nothing in evidence shows that the information or that the accused Colonel Joy had such information, nor could it be presumed as such. The record is also silent as to any information that was given to the accused Colonel Joy. It should be noted that the accused was already gone when the crime was committed, and neither was he informed or apprised of the same during and after the commission of the crime. In particular, the crime was committed under the instigation of Leader Wright and the willful participation of Sergeant Yu to kill the victims, and therefore these circumstances would tell us that these acts are not attributable to Colonel Joy, and that there was some indication whatsoever that would invite his suspicion or conclusion that the crime will be committed thereof. So we submit that since there is an absence of knowledge on the part of Colonel Joy, cannot be committed or cannot be charged with the crime of willful killing at Camp C. So at this point in time, I'd like to ask the court for your questions and please.
Counsel, can you clarify to this court again what's the third element of severe responsibility?
The third element for severe responsibility is that the accused had failed to take the necessary measure steps to prevent the acts or punish the perpetrators thereof, Your Excellencies. That is the third element for the command responsibility.
And would Colonel Joy, did he not fail to take necessary reasonable measures?
Your Excellency, since there is an absence of information in his part, it cannot be expected to punish the perpetrators thereof.
Would the second part of that element require him to submit the matter to competent authorities?
Yes, Your Excellencies.
After the commission?
Yes, if there would have been any information in his part that the crime was definitely perpetrated thereof by the malefactors, then it is the duty of Captain Joy to inform the same before the competent authorities that the crimes was committed or the crimes were committed by his subordinates and not by him as commander of camp. Your Excellencies, I would like to clarify further about the second requirement of knowledge under the requisites for severe command responsibility. Article 28 of the Rome Statute of the International Criminal Court and Article 7, Paragraph 3 of the Statute for the International Criminal Tribunal of former Yugoslavia use the phrase "had reason to know," to which our prosecution has pointed out that this element constitutes as constructive knowledge. But Your Excellency, this phrase has to be qualified with the additional Protocol 1 under Article 6 of Paragraph 2 the Geneva Conventions, which says that the fact that any of the acts were committed or breach was committed of the convention will not relieve his superior from his responsibility if he knew or had an information which would have been able to conclude him under the circumstances at the time that the subordinates were committing or about to commit such crimes. I guess Excellencies, my time has... Thank you, Your Excellencies. That, again, Excellencies, that this phrase had reason to know, as used under Article 28 of the Rome Statute of the ICC and Article 7 of Paragraph 3 of the ICTY statute. It may be, in some ways, similar to the phrase used under Article 8, under Article 86 of Paragraph 2 of the Additional Protocol 1, which says that there is a phrase that had information which would have enabled him or the superior thereof to conclude that the crime will be committed thereof by subordinates. It was ruled by the International Criminal Tribunal of former Yugoslavia in the case of prosecution versus Delali that the two may be similar in some ways, that they differ to a certain extent precisely because the other ones is more specific. It means that the accused or the perpetrator thereof had failed to conclude or had failed to conduct further inquiries in spite of an alarming situation which therefore constitutes his knowledge or which therefore constitutes knowledge on his part, and that his failure to act when being required to act with such knowledge is the basis of his criminal liability thereof. So under the facts of the case, it is beyond cavil that Colonel Captain Joy was not informed, or he was not even informed into the circumstances wherein he would conduct further inquiry with regard to the commission of the crime prior to and during after its commission, Your Excellencies.
Also, another clarification. Is it logical for me that Sergeant Ewell expressed his objections to the order of Captain Joy? Would that not alert him to the possibility that crimes will be committed because the subordinate is acting a bit against his orders? Thank you
for that point, Your Excellencies. That alone, the so-called belligerent character on the part of Sergeant Ewell would not warrant suspicion or conclusion on the part of Captain Joy to conduct further inquiry, because such information is insufficient. It should be noted that prior to the commission of the crime, he left an order with Sergeant Ewell to have the victims collected or to have the wounded and collected the casualty. However, it was through the defiance of Sergeant Ewell over the order of Captain Joy to have them rather killed and raped.
What standard of sufficiency would you prescribe for this court?
Your Excellencies, the standard of sufficiency that I would like to stress before this honorable court is that there is an insufficient information, or that the same is irrelevant or not specific.
Yes, what I'm asking is, what would you consider sufficient? By what standard do you consider an information sufficient for a commander to assume that crimes will be committed?
Thank you for the point, Your Excellencies. The standard of sufficiency of information that I would like to stress on is that such information would have enabled the perpetrator or the commander thereof to conduct further inquiry as to ascertain whether or not the crime was committed or were about to be committed by the perpetrators thereof. So there, at the very moment of time where we can say that the perpetrator had knowledge thereof, or that the commander rather had knowledge of the commission of the crimes of the subordinates. So if you have any further questions, Your Excellency, I would like to proceed to my next point. Thank you, Your Excellencies. There was also failure on the part of the prosecution to, I guess, Your Excellencies, I have 1 minute left as I mentioned. Thank you, Your Excellencies. Going back to what I said, there is also failure on the part of the prosecution to establish the requisite of failure to prevent. It should be noted that the principle of severe responsibility that or rather, the principle of superior responsibility precedes that superiors are only criminally liable for the acts of the subordinates as a result of their failure to exercise control properly over such subordinates. However, as what we have seen under the facts of the case, there is clear absence of information that crimes were committed by his subordinates, and therefore Captain Joy cannot just be held liable or cannot be expected to prevent the commission of the crime or punish his subordinates thereof, in particular Sergeant Duo for the commission thereof. Therefore, we can also see, or rather say that by this failure of the prosecution to establish the risk of failure to prevent, Captain Joy cannot be said to have committed the crime of willful killing. So at this point of time, I ask the court if you have any questions. Thank you, Your Excellencies. I would like to proceed to the next point. It should be noted that the order of Captain Joy was lawful under Article 33 of the ICC's or the International Criminal.
What order would that be?
The order to collect the wounded and the dead.
Sorry?
The order that I'm referring to, Your Excellency, is the order of Captain Joy to collect the wounded and the dead in the camp C to protect them from the dangers and perils of war. So, going back to what I said, Your Excellencies, under Article 53 of the International Criminal Court statute, it says there that the crime committed under the jurisdiction of the court would not relieve the perpetrator, the person of his criminal liability or responsibilities unless the same was not manifestly unlawful. Again, going back to what I said, the order of Captain Joy was collected within the camp C, and therefore it clearly establishes his lawful order over Sergeant Duo, and he cannot just definitely be held liable for the crime committed by Sergeant Duo out of his lawful order. So if you have no further questions, Your Excellency, I will now proceed to my second submission. Thank you, Your Excellencies.
Can you do a summary of the second submission?
Yes, Your Excellencies. Thank you. We submit in our second submission that there was no lawful confinement of civilians on the basis of ordering the crime, which would amount to a breach of the Geneva Convention of 1949. Precisely because the prosecution has failed to establish the requirement of protected persons under the grave breach regime of 1949 Geneva Convention, and if ever the citizens or the detained persons thereof in Camp Z or in Camp Q rather were protected with the Geneva Convention for the same was lawful under the category of measures of control and security which parties to the conflict may take according to Article 27 of the Geneva Convention 4. So at this point of time, I ask if there is any point of inquiry that this court would like to address on. Thank you, Your Excellencies. Lastly, again, just like the requirement of knowledge under the severe supporting relationship, or what is provided under Article 7, subparagraph 3 of the International Criminal Tribunal, the formally established provides that absence of knowledge on the part of the accused or mens rea, accused cannot just be held liable for the crime committed thereof by his subordinates. And this principle is also coined from the writings of the preliminarians that the international criminal law does not impose liability on the part of, or does not rather impose the duty on the part of the superior to do the acts that are completely beyond his control. In other words, to be held liable only for the acts that are within his powers. And that lastly, this principle of command responsibility does not also limit or does not also impose the strict liability on the part of the accused for the crimes committed by his subordinates. If you have no further questions, Your Excellency, I would like to proceed with the following to my co-counsel. Thank you, Your Excellencies.